Donald Trump submits his brief opposing Jack Smith's attempt to leapfrog the Court of Appeals and take this case right to the Supreme Court. The reason why Jack is going so fast is because this is the January 6th case, and he wants this trial to go on March 4th. Even though everything has been paused while this is on appeal, Jack Smith wants it to get resolved very quickly. And so we've already read through Jack Smith's original petition to the Supreme Court saying, can you please leapfrog the Court of Appeals? But now Trump is filing his brief in opposition. Jack Smith is going to reply on top of that. Remember, he's going to get the last word, and we're going to hear a reaction from Conway and from Trump himself. But diving right in to Trump's brief, here is what the defense team for the former president are arguing in the Supreme Court of the United States. The case is United States versus Donald Trump, and this is Trump's brief in opposition to the petition before the court. You know, it's the usual suspects here. We've got John Lauro and Todd Blanche, who are both writing on behalf of Trump. Now, here are the questions that are being presented. Now, they're concerned, actually, that Jack Smith's question is not accurate. So Jack Smith, when he submits his petition to the Supreme Court, he is posing a question. And what they say, starting out, is they say, guess what? Jack Smith's proposed question, it misstates the issue. It's totally wrong. It misstates the legal issue in this appeal by incorrectly framing it as whether there is absolute presidential immunity to crimes committed while in office. Okay, and we called that out from day one. Like, we didn't say that the president could commit crimes. It's immune from prosecution for official acts, one of which is making sure that elections are legitimate. Okay, so every time you hear one of the lefties screaming about, yes, Donald Trump can just execute the vice president then, if this stands. I guess he can just commit insurrection whenever he wants. If you're a smooth brain like Ted Lieu, who says that maybe that means Joe Biden can just seize power for indefinite lengths of time, that's all not what Trump's argument is, okay? The actual issue is about immunity for official acts, one of which is making sure elections are conducted appropriately because he's the chief executive of the country. It's their job. So the question is whether the doctrine of absolute presidential immunity includes immunity from criminal prosecution of the president's official acts, even if those official acts are within the outer perimeter. That's the question, they say, not Jack's interpretation. And the next question is whether the Constitution and double jeopardy, the principles there, would foreclose a president who's already been impeached and acquitted from being someone who faces criminal charges. And so those are the two questions. And they say Jack Smith really got this all wrong. They say these are the related proceedings. Here is our table of contents and our table of authorities. They say, guess what, Supreme Court, all 9 of you? This case presents a fundamental question at the heart of our democracy. Very simple, whether a president may be criminally prosecuted for his official acts. Now, this calls for this to be resolved in a very cautious, very deliberative manner, not at a breakneck speed. Okay, Jack Smith wants to go fast because he needs the conviction before the election. He wants the trial to start in March. But in 234 years of American history, no president, not one, has ever faced criminal prosecution for his official acts. Now, until 19 days ago, no court had ever addressed whether immunity from such prosecution even exists. But to this day, no appellate court has even addressed it at all. And so the question stands in front of us. It's one of the most complex, intricate, and momentous decisions that this court will ever be called upon to decide. Now, we have a normal appellate process for a reason. They say this court's ordinary review procedures, just allowing it to go regularly, will allow the district court to address this appeal in the first instance, thus granting this court the benefit of an appellate court's prior consideration of the historic topics and doing the traditional winnowing function that the court has preferred. Like, you got to go through the classes, right? Like, you can't just go play pro football. You got to work your way up. Indeed, the DC Circuit has already granted highly expedited review of this, and we've already had oral arguments. And so they say, hey, SCOTUS, Jack Smith is urging this court to bypass all of these ordinary procedures. We have a long-standing preference for prior consideration, and this court should decline this invitation to leapfrog over the rest of the case. And why? Well, we've got a couple reasons. They say, first, the government lacks Article 3 and prudential standing to appeal from a district court judgment. Now, you can't just do this. The government is not injured by this decision. This case doesn't fall within the narrow class of cases where they're allowed to do that, and so you can't allow it. And second, prudential considerations also weigh heavily in favor of this. Allow the DC Circuit to address this case. It's already at the Court of Appeals. And so here they say, in fact, right now it's already rapidly underway. The DC Circuit has already expedited this, and we're already scheduled for briefs. So Trump is saying we're already going to argue about this, okay? January 2nd and oral arguments on January 9th. So you don't need to come in front of the process. And this makes sense because Trump wants this to go slow. It makes absolute sense. And if I were representing him, I'd also want it to go slow because it's very important stuff. You don't need to accelerate everything. Now, third, they say, Jack Smith also identifies no compelling reason for the extraordinary haste that he proposes. He says in some vague assertion that public interest favors a resolution and that we need a dramatically increased timetable. He is confused, though. What he's doing is he's confusing public interest, which he thinks is nonpartisan, with his manifest partisan interest in ensuring that Trump is going to be subjected to a months-long criminal trial at the heights of a presidential campaign. The combination of an almost 3-year wait to bring this case demands that we give us the same amount of time to investigate. And fourth, they say the law that special counsel supports does not even support this request here in front of the Supreme Court. In Nixon, there had been extensive and thoughtful consideration of presidential privilege. We had multiple appellate decisions. It took 2 centuries between those things to get to the conclusion. But here, in Trump's case, that's not happening. The sum total of judicial grappling with this issue is on a 19-day-old district court opinion. That's all. Chutkan issued opinion. We've had an appeal, and we're just hashing through it right now. This history counsels in favor of allowing the D.C. Circuit to address this first, and then we'll get to the Supreme Court. And fifth, the ruling below was issued 9 days after a close of briefing because the special counsel wants this done quickly. But the result? No, it was bad. It was a hasty analysis of complex issues, and it overlooks the binding authority elsewhere. And so every jurisdiction here needs to consider this, and this case needs to appeal first to the D.C. Circuit Court of Appeals, which is where it is right now, saying haste makes waste. It's an old adage. It survived because it's right. Now, briefly, we'll just take a look at this jurisdictional statement, but they say, first of all, this court doesn't even have jurisdiction over this case, okay? Article 3, it says this court grants cert, which is what Jack Smith is asking for. When it grants cert, we don't want it to act as the court of appeals. A party seeking judgment before the lower level court must have standing to appeal the decision. But in rare instances, the Supreme Court may grant a petition to the prevailing party, but they've got to be able to really come up with an injury that they can address. In cases where a prevailing party's standing to appeal a favorable decision has been recognized, the ruling challenged on appeal decided against that party in a way that inflicted an ongoing injury to the party. And so, thus, an official whose conduct is deemed unconstitutional but is granted immunity suffers an ongoing injury from the decision, which is a de facto restriction on their freedom. And saying, so that's not the case here. Here, the district court denied Trump's claim of immunity and double jeopardy in total. So you can't separate things out, wrongfully holding that there is no presidential immunity and saying that Trump can be prosecuted. And so the judgment here is broad enough that everything gets paused and we have to appeal it. So the only injury that special counsel asserts in this appeal is just the delay of the trial date. So there's nothing else you need to consider. The government may be injured by Trump's appeal, but it's not injured by the district court's judgment. And the judgment is what is being appealed. Okay, like the government is different than the judgment. And the government is very upset about this. Like, we know they want Trump convicted immediately, but that's not alone a basis for expediting this. Like, just because you're mad doesn't mean you get to go to the Supreme Court. Now, moreover, even if the court had jurisdiction, which it does not, the court should not exercise it here. Okay, we want it to go through the Court of Appeals because that's the proper mechanism to do it. Now, in the rest of their statement, now that they say the court doesn't even have jurisdiction now, they're going to get into the meat and potatoes. They say this indictment alleges purely official acts. It's not criminal conduct. Okay, the idea that Joe Biden wouldn't leave office would be a new criminal act. Okay, Trump left office. They say on August 1st, President Trump was indicted. We know the background. But the indictment does not charge President Trump with any responsibility for January 6th. No. Instead, it talks about his political speech. It talks about his advocacy. The indictment alleges 5 types of conduct. We know what they are. Okay, the first one is Trump made a series of tweets. Then Trump communicated with acting attorney general. Then Trump talked to state officials about their elections. And then Trump talked with Mike Pence about the election. And then there were alternate electors. We got all of that. Now, all of those things, they say, is legitimate. Okay, those are his official duties. And that's what Trump does. Okay, is he makes sure that the country is working. That's what he does. You go around to different states. How are things going? How can the federal government support you? Blah, blah, blah. So in addition to all of those, right, every single one of those was an official act, all within the purview of the executive branch, because you got to make sure the country runs elections. Now, Trump, they're saying, also has a basis for dismissal. He also submitted two motions to dismiss based on the immunity issue and motion to dismiss based on double jeopardy. They say here, Trump filed those and he made his points. They say, first of all, presidential immunity is rooted in separation of powers, okay? The president occupies a unique position in the constitutional scheme, and he is basically the root power of the Constitution. Now, under our separated powers, neither a federal court nor a state prosecutor may judge a president's official acts. Those are his acts. And if he's allowed to do his acts, you can't insert your opinion about those acts, Liz Cheney. Likewise, no court or federal court has jurisdiction to sit in criminal judgment over them. Okay, you may not like what Trump said or did, but you're not allowed to make judgments on them. Otherwise, there is a problem with separation of powers. And second, they say President Trump argued that the impeachment clause presupposes that the president is immune. Why? Because the party convicted shall nevertheless be liable if you are impeached and convicted, right? You got to be impeached in the House, which Trump was, and then you have to be convicted in the Senate, which Trump was not. And so here they say that immunizes him, essentially. And so third, President Trump also cited evidence about this. He explained specifically, Alexander Hamilton wrote that the criminal prosecution of a president may occur after the impeachment and the conviction. Otherwise, various prosecutors all throughout America can just decide that they want to go take out a president and then indict him, as we're seeing happen right now. So they say fourth, in another case, immunity decisions have come from common law. And fifth, we have a history, a 234-year history of not prosecuting presidents for official acts. American history abounds with examples of other presidents who were accused by their political opponents of committing crimes. For example, John Quincy Adams said that there was a corrupt bargain by appointing Henry Clay as Secretary of State. And George Bush lied to all of us when he said that there were weapons of mass destruction there. Got us into a multi-year war, decades, thousands of good Americans dead, and trillions of dollars wasted into oblivion because he lied to us. Obama took out and killed a U.S. citizen, by the way. Talk about an insurrection. He killed his teenage son too, also a U.S. citizen. Both of those were located abroad, among many other examples. And so those are all lies, okay? People are accusing their opponents of committing crimes all the time. But each one of those were vehemently denied. But no president was ever prosecuted until this year. Of course, it's Donald Trump. So that's what they do. Now, the unbroken tradition of not exercising the power of prosecuting a president over centuries implies that the power does not exist, okay? If they could have prosecuted each other, you think they would have? But they didn't. Now, six, they say Trump pointed to analogous immunity doctrines for legislatures and judges, and they say that courts have recognized other types of immunity. We've got civil immunity, we've got judicial immunity, we've got all other types of political immunity, but not for the president? That doesn't make any sense. And seventh, Trump noted public policy also would prohibit this. The prospect of allowing prosecutions to be brought against somebody just because they don't like their politics is not good for America. Now, Trump made these arguments, and Trump filed a motion to dismiss based on these grounds, and all of this stuff is now working its way through the courts. And so Supreme Court, they say, here's some more background. We also know that there's a double jeopardy argument. Trump made this argument, and it's all worked its way through the courts, and now we are here. Continuing, saying, here are some reasons why you should deny this. First of all, this court's Rule 11 provides that a petition for cert before judgment will only be granted if there is imperative public importance that justify a deviation. So Jack Smith would certainly say there is, but Trump would say no. He said we can just go through the ordinary course of things. Now they say that prudential consideration should be taken. Okay, this judgment, what Jack Smith wants is extraordinary acceleration of this proceeding, but we don't need that. Here, Jack Smith urges, he says no courts of appeals should be allowed to explore the questions before this court grants certiorari. But Jack Smith is incorrect. Issuing a writ before judgment has the possibility of creating splintered decisions. And so we don't want the courts to have that. It's order of operations, right? You got to do your equations in sequence. And so they say Jack Smith, though, okay, the only reason, the only justification for this is because he says it involves questions of extraordinary importance. He said, you know, this case presents a fundamental question at the heart of our democracy that only this court can resolve. But he says, no, this is not right. Trump's defense continues, saying, but the importance issue here does not automatically necessitate speed. If anything, the opposite is true. Important stuff you slow down on. Novel, complex, sensitive, and historic issues like the existence of presidential immunity is very important, and we need to to slow down, saying, indeed, the fact that this case arises in a vortex of other political disputes warrants caution. We're in the middle of an election, so we don't need to go fast, especially when things are moving too quickly. So this case is both great and it's hard, which means we have to be deliberative. But that's not what Jack Smith wants. He says we should depart from these principles. Why? Because of the public interest. But he wants a compressed briefing. He wants something that is very difficult to get through quickly. In fact, he wants to move as expeditiously as possible. He demands an immediate resolution. He demands an appropriate timetable. But the problem with Jack Smith is he never explains why. Why do we need that? That date has no significance. Why do we need March 4th? In criminal law, it's not even important. The date has no significance. The prospect that an interlocutory appeal might affect the pending trial date, though, is the thing that matters. They're only concerned about the trial date because of the election, not because it has any other importance. They say Jack Smith creates an appearance of a partisan motivation. If there is no other extraordinary reason to do this, then we know what the real reason is. It's because President Biden is facing a threat from Donald Trump, saying the current potential trial date falls the day before Super Tuesday, one of the most critical dates on the Republican calendar. And this is right when they want the trial to start. This is all being brought to light because Jack Smith wants to get rid of Trump. And saying here, he confuses what he calls public interest with partisan interest. And this echoes other incidents, saying here, the Biden administration is doing this, according to Biden, for the good of the country. And millions of American voters certainly disagree. So we cannot allow Jack Smith to politicize the trial schedule here. And Jack Smith is threatening to tarnish this court's procedures. He's trying to drag the Supreme Court into the middle of this. And so the special counsel seeks to compare this case to another handful of cases, but those cases are all irrelevant, and he explains why each one of those is bad. In Texas, that's wrong. Commerce is wrong. But if we accelerate this, we're going to have hasty decision-making hazards, saying the government wants a highly expedited resolution of this case. They want 9 days of deliberation, but this is a problem. This is moving at breakneck speed, and this is filled with deficiencies. First, the court has emphasized that no court has ever accepted the doctrine of criminal immunity. And the district court held that there was no such immunity that exists. So these are major, major issues. And third, we also know that Alexander Hamilton, which was already cited, said that this was inappropriate and that the judge found some other incorrect findings in her analysis as Chutkan carried on. And so as you can see, they're concluding this for us. They're saying the indictment of Trump fits this bill and it needs to be postponed, writing that for the reasons discussed, even if this court grants certiorari, which it should not, we would require a briefing on this and it's going to take a lot of time. And so, Your Honors, in other words, long story short, do not accept this case right now. You don't have jurisdiction. It's not fully ripe yet. We still need to go through the Court of Appeals and figure out what is actually happening there and just go through the regular procedure. Okay, Jack Smith wants to go fast, but there's no reason to do that here. So Jack Smith submitted his reply, and that's what this one looks like here. So in the reply, Jack Smith responds. He says, oh, no, we actually do need to go fast. So this is from the deranged thugs there at the special counsel's office. They say, Your Honors, sorry, we do need to go fast, saying respondents, Trump, or us actually, we agree that the question is whether the issue is about conspiracy to overturn an election and prevent a lawful winner from taking office. And so they're disagreeing again with the framing of this. They say that's incorrect. This court is the only way to achieve a timely and definitive resolution, saying we agree this is a very important case, but we don't need to wait. The waiting suggestion is misguided. The charges here, they say, right? It's the charges. That's what's most important. It's the utmost gravity here. This case involves, for the first time ever, criminal charges against a former president, and not just any actions, in actions allegedly to install himself as the leader of the country permanently. And so they say their other arguments provide no sound reason to deny immediate review. He says the government lacks standing, but we don't think that. This case does warrant the Supreme Court hearing. There was serious criminal conduct, fraud against the United States, obstructing Congress, and blah, blah, blah. Right? We're familiar with all of that. Saying more than a century ago, this court, in considering this, gave a lot of concern to this back during the Civil War, and that the judgment here before the lower level court is appropriate, saying the circuit court, the Court of Appeals, they expedited this. The briefing schedule is moving quickly. And so basically we're going to be done with this. And then we're going to be probably be coming up to the Supreme Court, so you guys better be ready for it anyways. Writing, this court granting cert is in alignment with other historical context, like the Nixon case, and the stakes are just as high as what you did in Nixon. This case implicates a constitutional bedrock across America, and this court needs to resolve this before we can move forward. Trump's arguments lack merit, and any other briefings here are irrelevant. And so they tell us, for the foregoing reasons, you need to grant this right now because we got to get this resolved. And again, they didn't really talk about the election. I didn't see much in here about why the urgency is so important. I guess it's just the severity of the charges is really what we're seeing. He's got to stay of the proceedings. There are ongoing interests to dispute. And I guess the country just needs a resolution, right? So that's Jack Smith's response. And then we'll see what the Supreme Court says about this and really about whether even to just accept the case. So they're not going to give us a decision yet about whether Trump has immunity or double jeopardy or those things, just about whether it even gets accepted. And so we'll be waiting to see what happens. Jack Smith wants it there, and others certainly want it there too because they want the Supreme Court to kick it back down to Chutkan and have her put the trial back on track. Now, this is George Conway, who is saying this is a big problem. You know, if the courts don't find in our favor, our entire system is going to be at stake here. And this is what he said. You know, this is the first time I ever voted for a Democrat. Why? Because our whole system is being threatened. And he was hanging out with Morning Joe and Mika. And here's what these two sounded like.
Didn't codify Roe v. Wade. Joe Biden didn't stop my gas prices from going up. So I don't really care what Donald Trump's saying, whether he's quoting Hitler or not. I just want my prices to go down. Yeah, he's old. What do you say to that person?
None of that matters compared to what's at stake in this election. And Joe, more to your point, I'm 60 years old. I first voted in a presidential election in 1984. I voted in 10 presidential elections. 2020 was the first time I ever voted for somebody other than the Republican. First time I ever voted for a Democrat for president. And the reason is because our entire system is threatened by this one man and his supporters. None of these things that you talk about, student loan, none of these matter if a president can declare himself president for life and can call out the army and under the Insurrection Act to arrest whoever he wants, to shut down the media. And this is exactly what he wants to do. If he's elected in 2024, I don't know that he will be able to do all of those things, but he will try. And the fact that he tries will cause great damage, as he did over 4 years to this country. It will cause great damage to this country. It will paralyze the government and will cause civil unrest. And we will lose our democracy in the way that other countries have lost their democracies, by disorder and chaos. And we can't allow that to happen.
We can't allow that to happen. And so they're going to do everything they can. Keep him off the ballot, indict him multiple times, call him a racist, melt down over the blood comments. And really, I mean, the language is getting pretty bad, saying that he's a, like Hitler or he's like a Confederate and so on. And so they're really, panic level 10, hitting the nervous button over there. Meanwhile, Trump doesn't even know what Mein Kampf is. Here's what he says. I never even read that stupid book. Here's Trump.
They come from Africa. They come from Asia. They come from South America. But not just South America. They're all over the world. They dump them on the border and they pour into our country, and nobody's there to check them. And the Border Patrol is incredible, by the way. They want to do it, but they're told not to do their job. It's crazy what's going on. They're ruining our country, and it's true. They're destroying the blood of our country. That's what they're doing. They're destroying our country. They don't like it when I said that. And I never read Mein Kampf. They said, oh, Hitler said that in a much different way. No, they're coming from all over the world, people all over the world. We have no idea. They could be healthy. They could be very unhealthy. They could bring in disease that's going to catch on in our country, but they do bring in crime. But they have them coming from all over the world, and they're destroying the blood of our country. They're destroying the fabric of our country.
There, right?
They come from Africa.
And that is where we were explaining that this is the body politique metaphor, right? The state of a nation. What does the body politique look like? Is it a healthy body or not, right? It's the idea that crime and disorder and garbage and, yes, other things like fentanyl that might actually go into the blood are all problematic. That is what Trump is saying. But those people, I guess they want more chaos at the border. They don't think the entire system is threatened. It's wild to think this. Like, they think the system is, I think, in perfect shape. And then if Trump wins, it's going to be in disarray. Do they realize we've got like multiple wars breaking out across the world? We've got currency that is totally, in disrepair. We've got a border that's that's wide open, but these people are concerned about Trump. It's like their guy has caused all of this wreckage. But Trump is now battling at the Supreme Court. We're going to be here to see what the Supreme Court says. Of course, they're going to issue a ruling on this, and we'll look forward to seeing what it is. At some point, we do believe the Supreme Court is going to weigh in on this, but do they need to do it on this issue right now? Or maybe Jack Smith can just appeal it after the Court of Appeals. We'll see. We'll be covering, my friends. Thank you for subscribing. Thank you for liking this video, and also going to robertgovea.com to sign up for our daily newsletter. And if you want to read or access any of the PDFs, they are on there at robertgovea.com. And we'll look forward to seeing you back here on the next one.